Army's former chief legal officer in Iraq has told this programme that British forces have used and continue to use interrogation methods which are illegal under international law. In an exclusive interview, Lieutenant Colonel Nicholas Mercer reveals how he warned the Ministry of Defence as far back as 2003 of illegal techniques including hooding and the use of stress positions. But he says his warnings were ignored and he was overruled. Our Foreign Affairs correspondent Jonathan Miller has this special report, and you may find some of the content distressing.
Right, come on, get up!
The hooding and torture of prisoners by the British Army in Iraq has led to public inquiries, compensation payouts and government apologies. But could all this have been avoided? This man says yes. He was the Army's most senior lawyer in Iraq at the time of the invasion. Now, for the first time, he gives the inside story on how his advice was repeatedly rejected and how the MoD tried to silence him.
I mean, it's very hard to give legal advice that contradicts the government line they wish to be taken.
And he warns that interrogation tactics like this, still used by the Army and defended by Defence Secretary Liam Fox, are also illegal. Last week, after 20 years' service, Lieutenant Colonel Nicholas Mercer, former Commander Legal of British Land Forces in Iraq, left the Army. Tonight he tells us that the British broke international law in Iraq, and he claims there's a culture of what he calls moral ambivalence about human rights that goes right to the top of the Ministry of Defence. When the coalition invaded Iraq in 2003, one of the most important and sensitive jobs in the command was that of the Army's chief legal officer. It would be his job to ensure British forces in the field operated within the rule of law. That vital task was given to Lieutenant Colonel Nicholas Mercer, a highly regarded and successful career officer.
If you're the occupying power, you're the Army going in, you're the one who's responsible. You know, if you go into someone's country, you've got to do it properly. You've got legal obligations.
But almost immediately, Colonel Mercer, seen here in Iraq with Tony Blair, ran into a problem. It's a legal obligation that detainees are individually assessed to determine whether they're prisoners of war or civilians. And one of Colonel Mercer's legal team warned him that the process was being shortcut.
There were convening tribunals of 250 prisoners at once. My lawyer there objected to this because it was patently wrong in law and was threatened with being sacked unless he changed his legal opinion within 24 hours. I was threatened with being sacked. I stopped it and then we sorted it out. However, at the same time, whilst I was down at the prisoner of war camp, I went past the interrogation facility and saw the prisoners hooded and in stress positions.
These were techniques designed to soften up prisoners for interrogation and had been banned by the British government 30 years earlier. Colonel Mercer believed they broke the Geneva Conventions and he told his superiors so. They disagreed. But Colonel Mercer was not alone. The International Committee of the Red Cross had the same concerns and called an urgent meeting with the British Army, at which Nicholas Mercer was present.
I went to a meeting with the ICRC but was prevented from speaking at that meeting.
By whom?
By the Ministry of Defence.
Nicholas Mercer was beginning to realise that there were people who really didn't want him to do his job properly. But an even bigger problem was looming. Colonel Mercer was convinced that Britain was obliged to comply with European human rights law in Iraq. Once again, the Ministry of Defence disagreed. After the official cessation of hostilities, Britain legally became an occupying power, responsible for law and order. Colonel Mercer argued that the European Convention gave prisoners certain rights, which Britain was legally obliged to observe.
Now, like all prisoners held by the United Kingdom, as soon as you're arrested, the clock starts running. You're entitled to know what the charge is against you, you're entitled to have legal representation, and you're entitled to have a review of your case.
Colonel Mercer wanted to give prisoners that right to independent representation and safe detention. but the proposals were unequivocally rejected by his superiors in the MoD. The European Convention on Human Rights did not apply in Iraq, they said. Colonel Mercer says the plan would have prevented the circumstances which led to the death shortly afterwards of Baha Moussa, who died in British custody after 36 hours of beating, abuse and hooding. This year, the European Court finally ruled that the Convention on Human Rights did indeed apply to prisoners in Iraq, a decision that came too late for Baha Moussa.
Ultimately, you may have saved the life of Baha Moussa.
I think it would have been avoided.
And you would have saved the British government a lot of money.
Millions of pounds in compensation.
And you'd have saved the British Army its reputation in the Court of Human Rights.
I believe so, and I think we had the solution to this as early as March 2003. What's wrong with giving people human rights?
Today, Nicholas Mercer argues that the MoD is still failing to learn the lessons of that experience and continues to sanction techniques he says are illegal. These are internal MoD videos recording officers being trained in an aggressive interrogation technique known as harshing. The MoD believes the use of such techniques can be legitimate in a war zone, but at the end of the £13 million inquiry into the death of Baha Moussa, Chairman Sir William Gage said that harshing should be banned during questioning. But that call was immediately rejected by Defence Secretary Liam Fox.
The recommendation that we institute a blanket ban during tactical questions on the use of certain verbal and non-physical techniques, I'm afraid I cannot accept.
Do you think harshing is illegal?
I personally do, because I think that, and the guidance on this is found in the Geneva Conventions, that prisoners shall not be subject to violence and intimidation. That means no violence and intimidation, period, over.
How do you feel about the fact that Dr. Liam Fox has defended harshing?
Here we go again.
If it turns out that Colonel Mercer is right about harshing, the government's defence of the tactic could lead to yet another wave of claims against Britain. Phil Shiner was the Baha Moussa family's lawyer.
We've got a case coming up where we're acting for over 150 other Iraqis, but I think they themselves are still only part of the problem.
This is actual footage of one of Phil Shiner's clients being harshed in Iraq. He is threatened. He also complains he hasn't been given food or water for 2 days.
It's meant to insult, degrade, frighten, and for Liam Fox to say to Parliament, I am not following Sir William Gage's recommendation on harshing, is extraordinary.
In a statement to Channel 4 News, the MoD rejected the claim that they had a morally ambivalent attitude towards human rights, adding,
"The Chief of the General Staff has already apologised for the loss of discipline and lack of moral courage that occurred. Troops now undergo training in international humanitarian law. And in Afghanistan, where detaining and interrogating key insurgents is critical to our mission, high standards are being set and adherence to them is rigorously monitored."
And on harshing, they said it would in future only be used by
defined people in defined circumstances.
Last week, Nicholas Mercer, his career stalled and having lost out on promotion and additional pension rights, left the army. For the past 3 years, while effectively suspended for raising human rights concerns, Nicholas Mercer has been training as an Anglican priest. Last week, he was ordained. The MoD may have rid themselves of this troublesome army officer, but his words may yet come back to haunt them.